Keep Our Republic is a nonpartisan, nonprofit organization. Since the spring of 2020, we've been doing our part to help keep our republic. We do it through hyper-localized civic education. We talk with Americans through town halls, legal seminars, media briefings, and other events. We know a lot of Americans have a lot of questions right now about how our democracy really works. Questions like, what actually happens behind the scenes on election night, and just what is the power of the federal courts? That's why we're talking directly to election officials and judges from across the country. Together, we can help answer some of those questions. Welcome back, everyone, to Keepers of Our Republic, a weekly nonpartisan podcast from the nonprofit Keep Our Republic. If this is your first time joining us, don't forget to hit that like and subscribe button. We're putting out new episodes here every week on Thursdays, featuring important conversations with judges and election officials, discussing what is really happening in the worlds of courts and elections. In short, how we are together keeping our republic. This week, we are talking about a landmark ruling that just came out of the Supreme Court, striking down the Trump administration's executive order on tariffs. To help us break down what this quite complicated ruling means and what it could tell us about the state of the federal judiciary today, I'm bringing back two friends of the podcast. We have Judge Philip Pro and Judge Liam O'Grady. For those of you who didn't watch their previous episodes, Judge O'Grady is the former United States District Court for the U.S. District in Eastern District of Virginia, appointed by President W. Bush. And Judge Pro is joining us from the West Coast. He's the former United States District Judge for the District Court of Nevada, appointed by President Reagan. Welcome, both of you, and thank you for joining us. Good to see you again.
Well, good to see you. Thank you, Brooke.
Good to be with you and Judge O'Grady. Thank you.
Yes.
So for listeners who may not have followed this case closely, probably everyone has heard that something has happened to President Trump's tariffs. We've seen a lot of that in the news, but they may not be familiar with sort of the nitty-gritty of this case. They may not have ever heard of something like IEEPA. So can one of you just give us a very brief summary? What is going on in Learning Resources, Inc. v. Trump, and how did we end up here at the Supreme Court?
But by way of background, I think it's important if we just put it in perspective and recall that about a year ago when the president took office, he embarked on a series of executive orders. These are orders issued by the president under Article 2, his powers under Article 2 of the Constitution, changing or effecting a lot of policies that he felt were important. And rather than pass legislation through Congress or attempt to do so or take any other approach, he started moving with these executive orders, and many of them were controversial. They provoked a lot of litigation throughout the United States, seeking preliminary injunctive relief to prevent them from taking effect. And these dealt with immigration, healthcare, economic reforms, and so forth. One of the major areas that he was stressing was the use of tariffs as a way of improving the disparate trade balance between the United States and many foreign countries. And these are classically used for those kinds of purposes. Most people probably are aware of what a tariff is, but essentially it's a tax. And it's a tax on imports that are brought into the United States from another country. And it's designed to generate revenue for the United States Treasury in part. The cost is borne by the country exporting to the United States and by the importers and by all of us as consumers in the long run, because it does raise the price of goods that are imported. Well, it's generated some controversy and opposition, and Learning Resources was a company that was impacted adversely by the imposition of these tariffs because it received most of its products from outside the country. And they brought litigation to try and prevent this from taking place, basically alleging that the president didn't have the power to impose tariffs unilaterally by way of an executive order, that power was vested in Congress under Article 1 as a tax. And that's what started the whole piece of litigation. It percolated through the district court to the Court of Appeals and then to the Supreme Court. And the Supreme Court took it on an early setting, heard arguments in last November, and just issued its decision last week. So I think it's a week ago.
Yeah.
Yeah.
Judge O'Grady,
yeah.
please go,
Well,
feel free to jump in.
I'm just going to back up just a little bit for foundation purposes, as Judge Pro has said. The Article 1 of our Constitution covers what the legislative branch does. Article 2 covers what the executive branch does, and so you frame it all the way back to the Constitution, which judges are required to do, and Article 1, Section 1 says that all legislative powers herein granted shall be vested to Congress in the United States, which shall consist of the Senate and the House of Representatives. And then if we go to Section 7 of Article 1, it states that all bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. So there we have raising revenue. And then Section 8 states that Congress shall have power to lay and collect taxes, duties, imposts, and excises, and to pay the debt and to provide for common defense and general welfare of the United States. And so there, as Judge Pro said, there's the authority, exclusive authority to collect taxes, and tariffs are taxes. And so the president can only impose taxes under certain circumstances, and it's usually an emergency basis. And in this case, he used the International Emergency Economic Powers Act, which allows the executive to allocate, investigate, regulate, compel, nullify, void, and prevent the importation or exportation of goods in an emergency situation. And he found that there was such an imbalance in the trade deficit, specifically for drugs and also generally in the tariff, that he imposed these tariffs against a wide range of products, and based on a country by country evaluation of how our business has suffered because of the pricing imposed by those foreign entities.
That's a great summary. And like you said, that Emergency Power Act is IEPA. It's an acronym that's being thrown about a lot in this conversation. So thanks for clarifying that. Judge Pro, let's pretend we're in law school again for a second. In 1 to 2 sentences, could you describe, what is at its heart, what was the court being asked to decide in this case? What was the constitutional issue or statutory interpretation issue that they were being asked to look at?
Yeah, the court was called upon to decide whether under IEPA, and most of us had not heard of the International Emergency Economic Powers Act. It was passed in 1977, and I was really pretty ignorant of it, but IEPA for short, was called upon to decide whether IEPA authorized the president to impose the tariffs. And the court gave a definitive answer: no, he could not. We could talk for hours on the machinations that they went through interpreting the statute, IEPA, the language which the court ultimately, the majority of the court in the 6-3 decision concluded was too vague to, under any standard that they use to interpret these statutes, to allow that. And I think I pulled out one paragraph from the conclusion of Chief Justice Roberts' majority, which I think sums it up very crisply and lays groundwork for things we might productively talk about. He wrote, "We claim no special competence in matters of economics or foreign affairs. which is good because I don't claim any expertise in that either. Judge O'Grady may have a great expertise or not. Most federal judges are not. We're not called upon to judge the court was not called upon to judge the merit of a tariff with respect to China or Burkina Faso. I mean, just those weren't the issues.
We weren't asking them to be economists, right?
No,
Like that was not, yeah.
And the chief said, we claim only as we must the limited role assigned to us by Article 3 of the Constitution, is where the courts, of course, get their power under the Constitution. Fulfilling that role, we hold that IEPA does not authorize the president to impose tariffs unilaterally. And that's a very important, in my view, provision, a strong declaration that reinforces the concept of our separation of powers fundamentally, which is so fundamental to our Constitution.
Absolutely. I'd had that exact passage highlighted when I read through the opinion as well. I think it puts it so succinctly. Robert says
yeah.
him or his clerks rather have a way with words from time to time. I think that is lovely to read.
Judges get a lot of help from their law clerks, I can assure you.
Shout out to the law clerks for sure.
Absolutely.
Judge O'Grady, so as Judge Pro just referenced, this was a 6-3 decision, which included concurrences in part and concurrence in the final holding by judges Barrett and Gorsuch, who were of course both themselves nominated by President Trump. Is that surprising to you? It certainly seemed to take some members of this administration by surprise, but how surprising do actually either of you find it when justices rule against the president or the administration that appointed them?
I wasn't surprised at all, nor do I think that there are political boundaries that Supreme Court justices operate under once they become members of the Supreme Court. It's just like Judge Pro and myself when we became district judges. We may have been nominated by one president or another of one party or the other, but once you get into the courthouse and you put on the robe, there's no longer any political distinction. The Supreme Court, of course, has been, especially these last couple of years or last year after all the emergency orders have been issued, is suspect. And we maybe talk about it in a minute about how that's hurt the image of the judiciary as an independent body. But I thought Judge Gorsuch's concurring opinion was fascinating because he took a look at that the major questions doctrine, which allows courts to look at the breadth of a statute to see whether implicitly the authority of the executive in this case is proper. And he went back into the Biden administration and he started talking about the big decisions where the major question doctrine, which I think is a doctrine which really represents a statutory interpretation of statutes. How broadly can you read it? And the more important the issue, the less broadly it ought to be read. And so in the Biden administration, he had some historic attempts to use statutes that for good cause in his mind, were they did they fit within the statutes that he used as the roadway to impose those issues that he believed were important? And you had the eviction moratorium during COVID, and he used an act that was from the Surgeon General's Act, The vaccine mandate was from OSHA. The Clean Air Act, he used EPA and the Environmental Protection Agency and to eliminate coal power plants. And the major question doctrine was used to review whether he had that authority under that act. And the same thing was done here in the votes on those when those cases came to the Supreme Court were varied. The politics was not as important as people think it was.
That's a wonderful explanation of what happened in this case and the major questions doctrine by Judge O'Grady, and I totally agree with his analysis. But I want to also adopt and agree with the first comments he made. Were we surprised to see Justice Gorsuch or Justice Barrett issue a concurrence? And in the case of Judge Gorsuch, if we have anyone who's listening to this podcast and really doesn't have time to read 170 pages, I would recommend reading the majority or the base opinion by Chief Justice Roberts, which is only about, I think, 20 pages, and Justice Gorsuch's concurrence, which is a little over 40 pages, which really is very detailed and explains and reveals some of the inconsistencies. And this may be where the suspected view that these judges were appointed or justices were appointed by different presidents, and hence it's predictable who they're going to side with. And Judge O'Grady is exactly correct. When he and I came on the bench, in 1987, I was in the last group of confirmees to be appointed and confirmed before the Robert Bork hearings for the Supreme Court. And the wisdom at that time was, gee, this is going to alter the confirmation process. And it did in significant ways. But that wasn't necessarily the product of the judges that were being nominated or the people that were being nominated. That was the political dynamic of the time. And the judiciary in many ways has been so politicized. But honestly, I know every judge can probably say this till they're blue in the face, but as Judge O'Grady so aptly said, when you put that robe on, when you enter the bench, enter the court, this doesn't matter. I never cared a whit who appointed me or what political party was in the majority at the time that I was confirmed. That is just not something and that's the beauty of what this case illustrates. It illustrates not only a strong support for separation of powers, but for the independence of the judiciary, which has to exist so that we can serve the interests of the rule of law, which is the very foundation of our Constitution. The judges are free of political, unless they choose to be otherwise, and I'm not saying no judge has ever done otherwise, but the vast majority of judges in the federal courts, and I've known a lot of them in my 35 years I was on the bench, you wouldn't know what their political leanings were from the decisions. And at the district court, maybe that's even more understandable. It's not a hypercharged environment in most cases, but I know the public sometimes, probably because it's so politicized in the press, it's so politicized by those who hold political office, including presidents, to be sure, that they think it's otherwise. But
I mean, it doesn't help that it feels like your legal name at some point was changed to Philip Pro, appointed by President Ronald Reagan. They're inseparable.
And I promptly became a nonpartisan, and I've been nonpartisan ever since. And frankly, I'm a lot more comfortable being nonpartisan and adhering to any political party, I'll tell you.
So you talked about separation of powers, judicial independence, checks and balances. I wanna go back to both of those briefly for a second because this case is, as we've all pointed out, like just a textbook example of a lot of these foundational principles of
Yeah.
our Article 3 courts and how that interplays with the other branches. So, here we've got the Supreme, our article, head Article 3 court, the Supreme Court, interpreting a piece of legislation passed by our legislative body as to whether a power was delegated to the executive through that it gave a power that the president could exercise through executive action. It's beautiful. They should put this in an AP Gov question for the test next year. So let's talk about how do you think this case like really illustrates how the system of checks and balances is still functioning in this
Mhm.
country? Because I think a lot of people are starting to despair and feel like the system is fundamentally broken. And I would at least argue that this case is a good example of showing that it isn't.
Right.
Yeah.
Judge O'Grady, you want to take a stab at that?
Sure. Well, yeah, as Judge Pro has stated in some other podcasts, the courts are reactive. Yeah, and we need a real case and controversy before we do anything. And so we have the executive who decides he can use the IEPA to regulate tariffs. Learning resources and BOS Select decide that they don't believe that the executive can do that. It's a congressional power. And I've got to put this plug in for Madison from our founders, who said that we give Congress alone the access to the pockets of the people.
Yeah.
And that was just a wonderful quote, and came out of the decision. And so then it comes to the court, which determines whether the executive and the legislative branch have properly used the constitutional authority. And our job is to protect the people from abuses of, not abuses, but of excessive use of what our Constitution allows the government to do. And in this case, we have a legislature which had not responded to what the executive felt was a dire need of a readjustment in our trade deficit. And so he took it on his own to do that. And our Supreme Court said, no, you can't use the IEEPA to do that. That it's an emergency power. It's for the regulation of importation and exportation, and it's not to raise tariffs. It's too far afield. So it was a very natural process. It went to the Federal Circuit Court of Appeals, one of them, and the other went to the District Court of Columbia. They looked at it. They found that it was not a power that Congress had from that act. And I'm sure we'll talk about it in a moment, but then the executive branch goes searching in their Rolodex to find, well, how else can we affect what we think is a very important matter and move forward.
The Chief Justice, in his opinion, I think it was the Chief Justice, it might have been Justice Gorsuch who commented on this, but I'm sure it was the Chief. The Congress knows how to pass legislation that expressly or explicitly confers certain power on the president. When it uses the language as it used in IEPA that was vague, I think it was the Chief Justice pointed out, they could have quite well have just said, we're conferring this power on the president under these circumstances. It did not do that. And so that calls upon the court to do its interpretation. And it illustrates, again, when you asked about separation of powers, when when I talk to students, and I do that a lot in schools about the Constitution and the separation of powers, I'll use metaphors like a three-legged stool, an inherently stable platform, as long as all three legs of that stool are vibrant, strong, and can provide support for that platform. But you can also think of it as three lanes on a highway, each carrying a different vehicle. The branches are each assigned a particular lane on that highway. They're given powers from the people that are articulated in Articles 1, 2, and 3 of the Constitution. And the people driving those cars or vehicles, two lanes are being driven by people who were elected to political office, Congress and the president. And one, while I won't say it's totally without political influence when the appointments occur, is judges appointed for life. And part of our job when you talk about checks and balances is that we serve as the traffic cop, if you will, to make sure that each of the other branches stay in their lanes. It's natural for anybody who's elected to political office to want to enact legislation or use their power to respond to the people that elected them, the popular opinion. And nobody is going to fault somebody for trying to do that. That's what they feel and probably are right they were elected to do. But the problem is that oftentimes they go too far. A president will look at having to go through Congress, which is split very closely, as an unnecessary obstacle. I want to do this. I want to get there. And I'm not going to allow something like Congress to stand in my way. Well, yes, you are. And that's what the Supreme Court said very clearly. Yes, you are. You've got to follow the Constitution. And that's the function and the job of the judiciary, because it's very difficult for the other branches to police themselves.
So let's talk about judicial independence for a second. Something we've mentioned on this podcast here quite a bit is this idea of independent judges. And independent judiciary was incredibly important to the founders. We know that from every document they gave us, based on their own experience with the king being able to interfere quite intensely with the courts before the revolution. And they wanted to avoid a similar situation where someone's paycheck or career or status would rise and fall based on the whims of how the king felt about how you ruled. So what do you think this ruling, where we have even a number of justices ruling against the administration that originally nominated them before they were confirmed, ruling against that administration, feels novel when you consider, the history of judiciary in the world. So what do you think this kind of ruling says about the state of an independent judiciary in this country?
It's strong.
Yeah.
And I don't think there's any other way to read this opinion as anything but an affirmation of that fact. You pointed out that historically, when the Constitution was being written and some of the founders, the framers, were writing the Federalist Papers, Alexander Hamilton, and he's quoted somewhere in one of the opinions, he pointed out the accumulation of all powers, legislative, executive, and judicial, in the same hands may justly be pronounced the very definition of tyranny. Well, that was exactly what our Declaration spoke against, with the list of grievances against King George of England as to why we were going to form a separate union. And this is essential, and we must have that authority. Otherwise, if every decision were made by the judiciary, either adhering to the will of the president, qua king, or the finger to the wind and the popular opinion of the day, rather than what the law requires as they understand it, it would be chaotic, and it wouldn't be a very effective government, and we wouldn't still be a government after 250 years. Justice Kennedy, said it very clearly. Judicial independence is not conferred so that a judge can do what they want. Judicial independence is conferred so that a judge can do what they must. And what they must do is follow the law, follow the rule of law. That is so fundamental, and that's the goal every judge I know seeks to serve.
I want to turn now briefly in our last couple of minutes to sort of the partisan and public response to this ruling. It's been even people who have never heard of IEPA before last week, which was many of us. We've heard about this ruling. It's been all over the headlines. And we've seen a good deal of very strong rhetoric, usually following partisan lines, about this ruling. Not as much in this week's State of the Union as perhaps we had been concerned we would hear about. But why do we find when we have politicians attacking the justices personally when they issue a ruling that has political implications for them, why is that concerning, and why should that be raising red flags for people? Judge O'Grady?
Yeah, well, I wanted to say first that Judge Pro analysis of the independence of the judiciary was wonderful, and the rule of law gives a public predictability on businesses and persons and individual liberties that are so essential to our society operating properly. So now we have the executive, and it's not the first executive who has ever criticized a Supreme Court opinion. It's been happening and perhaps building up over the years. But so you have the president saying that his nominees should be ashamed of themselves, and that the decision was ridiculous. And although he didn't spend a lot of time talking about it, those are comments which are pretty strong coming from the President of the United States. And for people who aren't going to read the decision, which is 99.9% of the public, they get their information from other sources. And so it's always troubling. It doesn't matter that the president criticizes or the Congress criticizes a decision. That's part of a judge's job, is to take criticism, and they know that's going to happen, because every decision we reach is 50% of the people are going to be unhappy, and 50% happy, or maybe less than 50%. So that's a daily response to decisions by courts. But when you personalize it and you trivialize the role of the judiciary, and then it undermines the confidence that the public has in the third branch of the government. And that's so important to the operation of our country. And Judge Pro and I have both had occasions where we had members of the judiciary in foreign countries where judges were appointed by legislatures or the executives and could be removed at will. They're not democracies. They're authoritarian governments where the people are not protected from the experiences that Judge Pro spoke of a minute ago. And so it's so critical that the public understand and be confident in the decisions that our judiciary is making.
That's awfully important. We rely as judges on the confidence of the public. And the unfortunate thing about the caustic kinds of rhetoric that we've been seeing the past year from this administration directed at judges is not that they disagree with decisions and they express their disagreement with decisions. That's certainly appropriate political commentary, and hopefully a discerning public can understand that that's a point of view and opinion. It's not gospel unless they read the opinion and think it's wrong. But when it's shouted from that bully pulpit of high political office on the internet, on all forms of social media, that's radically changed the way the public perception is driven, I'm afraid, since, as Judge O'Grady aptly said, 99% of the people won't read the decisions and make an informed decision on the opinion written. That does damage to the fabric of the judiciary in this country. It's not going to change the way the judges approach their cases, but when you have personal attacks on judges or their families, I mean, that is absolutely, I'll say it for what it is, it's totally irresponsible for anybody in high political office to make those kinds of attacks. And that's something that I wish we could, and we try very hard to suggest that these should not be the way you respond to decisions that are made by the courts. But, they are, and they'll do what they're going to do, and the courts will do what they have to do.
Judges, thank you so much for taking your time to talk about this interesting, important ruling this week. It was a fascinating conversation, hopefully not just for the legal nerds like myself, but all of us, because it has such profound implications for our rule of law, for our Constitution, and for our country as we sit here on 250 years of quite the experiment. It's nice to see it still chugging along in such an interesting way with this ruling. Thank you both so much for joining me, and I look forward to having you both back on the podcast sometime too. We'll have to do this again.
Let's do it in 250 years hence, and we'll see how things have been going. But I'm sure we'll still have a Constitution.
Yeah, I think we'll.
I'm confident as well. Yeah. So much fun to join you both. Thank you.
Thank you, guys.
Good to be with you.
Good to be with you too. Have a good one.
If you like this episode, please share it on social media and tell your friends. It's the best way for folks to find out about us. I hope you'll agree that our guest is indeed a keeper of the Republic. If you want to learn more about how you can help keep our Republic, stop on over to our website, keepourrepublic.org.